Good morning. Welcome to the webinar about all things flexible. Flexible furlough, flexible working and flexible working locations. I hope that you're all well and that if you haven't done so already, you are on track for moving your laptop out into the garden this week. Looks like it's going to be a scorcher, which is good news. Right, so got quite a lot actually to talk to you about this morning. Sessions obviously booked in for sort of 30 minutes, but it might be 30, 35. We'll see how we get on. I don't talk to many people in lockdown, so when I get the opportunity to chat, I take that with both hands. So yeah, do please bear with me if I run slightly over. Just before we start, just like to do a quick sound check, if that's possible, please. There's a Q&A box at the bottom of your screen. If someone could just type, "Yes, Charlotte, we can hear you," that would be amazing. Brilliant. Thank you very much. That Q&A box, hello, that Q&A box as well can be used during the session if you have any questions for me. Like I say, I've got quite a lot to sort of talk to you about, but I'll do my best to answer any questions that you may have. If I can't get round to them during the session, then fear not. I'll be prepping a Q&A sheet after the session, which will be sent out to all of you. So everything that you want answering will get covered in due course. Right, so all things flexible then. Some people say the future is bright. Some people have in the past said it is orange, but I say that the future is quite simply flexible. Whatever I think your views are on flexible working practices, there's no escaping the fact, I don't think, that they are here to stay. Employers and businesses are obviously going to be managing the fallout from the COVID pandemic for some time now, and you know, irrespective of Boris's forthcoming announcement tomorrow, I think that socially distant practices will probably be with us for some time, which will obviously have the effect of forcing some employers to implement flexible working procedures in order to actually adhere to those provisions. However, I think in the post-COVID world, it seems very likely that many employees in particular are probably going to want, expect and possibly need flexible working, and employers, I think, should therefore be given serious consideration now to ways in which they can adapt their working practices in order to meet with that potential shift in expectations from the nation's workforce. During this session, I'm actually going to talk to you about all things flexible, and in particular, I'm going to give a brief outline of the flexible furlough scheme and where we're at with that to date. I'm going to give an explanation of all the existing legal and best practice principles in relation to employee flexible working requests. And I'm also going to try and give you a bit of food for thought and some practical tips when it comes to preparing for more permanent home working, because I think that's certainly something that is going to be a hot topic as we move out of the COVID sort of crisis as we currently know it. Just at this juncture, I think it's probably important and perhaps obvious to state that when it comes to the flexible future, there's not going to be a one-size-fits-all solution. Each business will be different in terms of its needs, its desires. But what I would just like to say is that there's always a way. With employment law, and we're here to support you to find that way or ways for your business. So anything that you need in respect of anything flexible, you know where we are. Just get in touch at any time, and we're more than happy to sort of talk through any proposals or plans that you might have for the future. One more thing, just before I get into the meat of things. When I was writing this session over the weekend, I typed the word flexible about 95 times. I think I've already said it about 15. And I couldn't get out of my head that old Mr. Bean clip. I don't know if, I really hope some of you out there know what I'm going to say. And it's when he's sat on the park bench and he's making a sandwich, and he gets out his credit card at the end and butters his bread and sort of just utters the words, "My flexible friend." Anyway, it's if you haven't seen it, it's worth a watch. But that was what was in my mind as I was writing this session. Right, okay, moving swiftly on from Mr. Bean. Flexible furlough, the latest. So about a week and a half ago, HMRC released details of the flexible furlough scheme. David Richards, wonderful, like it. Know exactly what you mean, or should that be Bean? Thank you, David. Yes, the flexible furlough scheme released, details released about a week and a half ago, due to be implemented on the 1st of July. Now, under this scheme, employees are no longer going to need to avoid during any work for their employer in order for a successful claim for furlough pay to be made under the CJRS. And instead, they can be furloughed for some of the week and work for their employer doing a full service for other parts of the week. The proportions of non-work and work are totally up for the employer and the employee to decide based on business needs ultimately. Employers will be liable to pay their employees for any work that they do, but like I say, for any work that they do not do, for any furloughed hours, if you like, the employer can still claim under the CJRS. It might be useful for you to note at this stage that when you're looking at implementing flexible furlough, you don't simply have to look at days. You can actually look at part days or even hours. So it's therefore okay for someone to work in the morning, for example, but be furloughed in the afternoon. Similarly, it's perfectly okay for someone to work 2 hours of a normal 8-hour day, be paid for those 2 hours, but for you to claim furlough pay for the 6 hours which aren't worked. Obviously, the whole point of the flexible furlough scheme is to allow employers to be flexible. And the government, I think, has done a pretty good job in terms of giving employers the widest remit possible in respect of getting employees back into work between now and October. In some respects, then, the flexible furlough scheme is very straightforward insofar as its primary tenet is the allowing of furloughed employees to work whilst furloughed. But as with anything employment law related and anything furlough related, in other respects, it's really complicated. The guidance is all over the place. Kudos to anyone out there who's read it all. It's sort of confusing. There's extra rules about how employers have to calculate flexible furlough pay, and there isn't a huge amount of guidance in respect of the question of how flexible can an employer expect an employee to be under the flexible furlough scheme. So, for example, we don't really know whether an employer has to give an employee very, very, very clear details in terms of the hours which they are to be worked each week from the 1st of July, or whether it's simply permissible to place employees under a more general requirement to be ready to work as and when during normal working hours, with a more kind of flexible approach to the notification process in terms of the hours to be worked and when they're to be worked. Even though the guidance is a bit hopeless, I think the answer to that question probably lies somewhere in the middle. Employees are obviously contractually obliged to be available to work when their employer has work to do. And therefore, in theory, if a business wants to look at bringing people back sporadically, this will be totally fine. However, these are completely unprecedented times, and obviously, employees are juggling plates left, right and centre. They have work commitments, childcare commitments, perhaps illness, maybe, either in respect of themselves or family members. They may have caring responsibilities, they may have shielding obligations. And it remains very much the case that during the flexible furlough scheme, an employer is still obliged to take these into account when placing employees under a requirement to return to work under that scheme. It's a horrible word, but employers still need to act reasonably when it comes to placing employees under a requirement to return to work. And there's no sort of easy way around it, really, insofar as each employee's own individual circumstances are going to need to be considered by the employer when they're making a decision about whether it's reasonable for them to be required to come back to work. For example, it's not going to be any good, I don't think, an employer forcing an employee with known childcare responsibilities to come back into work when the schools are shut and there's no childcare. And I think in that respect, in that example, if that employee failed to properly account for the childcare issues, then at worst, that could then lead to the employee turning it round, arguing that the employer had not acted appropriately in terms of the relationship of trust and confidence, and maybe seeking to resign and claim some kind of constructive unfair dismissal claim against you. Like I say, I think that's absolute worst case scenario, and I certainly haven't come across it in practice yet, but it is a risk, and one obviously to be aware of. Just on the childcare point, obviously very contentious for a lot of people, employers and employees alike. There isn't any specific guidance about how to deal with the issue of childcare in practice. And at the moment, all I can really do is impress the importance of considering each case in isolation and, like I say, acting reasonably. There have been a few questions ahead of this session about childcare and furlough, so thank you for those. But I think that it would probably be best if we had a chat outside this session to talk through your individual concerns. So by all means, pick up the phone to me after this session if you do have anything that you want to chat through in that respect. In terms of the flexible furlough scheme and its operation then, for the most part, it is exactly the same as the existing furlough scheme, but there is a very significant and I think welcomed change insofar as the minimum 3-week furlough period is disappearing. So as of the 1st of July, you're not going to have to furlough someone or flexibly furlough someone for 3 weeks in order to be able to make a claim under the CJRS. Any claim through the CJRS is going to be in respect of a minimum 1-week period now. And employees who were furloughed prior to the 1st of July, but after the 10th of June, must still be furloughed for the full 3 weeks before you can either make a claim under the CJRS or place them on flexible furlough. So, for example, if you're furloughing somebody today, then you are going to have to furlough them for 3 weeks, so taking you to the 2nd week of July before you can make a claim for the furlough pay from the government. You can't rely on this removal of the 3-week minimum in order to sort of get around the rules, if you like, in that respect. Some other headline points on the flexible furlough scheme that I think that you should be aware of is that a requirement for any flexible furlough arrangement needs to be in writing and it needs to be agreed with your employees. This is a really important point because the government have indicated that actually if you don't have a written agreement in place with your employees, then they might actually this time around refuse to pay you. So for those of you who are clients, this morning you will see an email pop into your inbox that takes you to a template flexibly furloughed written agreement for your use. I've also attached some guidance notes to read alongside that agreement. So do have a look at that. And obviously if you've got any questions, just get in touch anytime with either myself or any member of the team. Second point is that from the 1st of July, full furlough will still be permitted. You don't have to flexibly furlough someone if you have no work for them. You can still fully furlough them, just in the same way as you have done previously. All the holiday rules are the same. Holidays will still accrue from the 1st of July, but an employer can still compel an employee to take annual leave during any flexible furlough period, including bank holidays, as long as you give the required notice, which is obviously twice. I can never say this properly. When you want to compel an employee to take annual leave, you have to give them notice that's twice as long in length as the amount of holiday that you want them to take. So if you want an employee to take a week's holiday, you have to give them 2 weeks notice. If you don't give an employee notice of holiday, or if you don't want to compel them to take the leave, then it will just roll over to take when they're back at work. And obviously we have the rollover into the next 2 years as well, where it's been not reasonably practicable for the leave to be taken. So plenty of options when it comes to annual leave. Couple of questions. Does a furlough letter need doing each time an employee is placed on furlough? Yes and no. So have a look at the agreement that we've prepped. Basically what that does is give a general right to place on flexible furlough, and it gives the employer the option of setting out what it thinks the flexible working pattern which it wants to implement is going to look like. However, if you want to change that working practice, or you want to change the terms of the flexible furlough arrangement, you will need to write to that employee again. And it will be certainly very advisable for you to prepare a side letter, perhaps, that annexes to the wider flexible furlough agreement that you have in place. Can you just clarify about minimum period of furlough? We have some employees who were furloughed for 2 months and returned to work last week. Can we flexibly furlough them from the 1st of July, or will they need the 3-week furlough again? In that case, you'll be able to flexibly furlough them from the 1st of July because they have previously been furloughed for the required 3-week period prior to the cut-off, which was the 10th of June. If you have furloughed someone post 10th of June, then it's only in that case where you have to allow the full 3-week period to run before you subject them to the flexible furlough scheme. Moving away then from flexible furlough onto flexible working. I don't know if anyone's keeping track of how many times I've said flexible now, but I reckon we must be up into the 50s. So for those of you who attended my last webinar, I spoke to you about how an employer can vary an employee's terms and conditions of employment. And I always think that a good way of looking at flexible working, or the notion of flexible working in the legal sense, is that it sort of flips that variation process, and it becomes the way in which an employee, as opposed to the employer, can lead on a variation process. Now, I think that as we move out of the COVID pandemic, it seems likely that there will be an increase in flexible working requests from employees in a general sense. I think that some employees will need to look at working flexibly because of how the COVID crisis has affected their personal circumstances. But I also think some employees will want to work flexibly. I think that the COVID crisis has had a nice effect in some ways, insofar as it's allowed people to sort of reassess their priorities. And it may be that you get requests from individuals who want to sort of work better on a more work-life balance. Either way, I think that, like I say, we'll see an increase overall. And on that basis, I think it's important that you know about what your obligations are in respect to flexible working requests. Flexible working requests aren't new. They've been around for a very long time. And the current process that an employee and an employer must follow in the sense of flexible working have been in, or has been in place since July 2014. The scheme, it's a statutory scheme, so an employee has a legal right to make a flexible working request, and an employer has a legal obligation to consider it. For those of you interested, the flexible working scheme is set out in sections 80F 280I of the Employment Rights Act 1996, and is supported by the flexible working regulations. So if you're interested, by all means, have a read through those. And if you want to talk about the ins and outs of the legislative provisions, happy to chat. The legislation is also supported by 2 ACAS documents. Now, even if you're not interested in legislation, I would strongly recommend that you read these notes, because when looking at an employer's approach to a flexible working request, a tribunal will have to take into account an employer's adherence to these provisions. So it's a bit like the ACAS Code of Practice on Disciplinaries and Grievances. The tribunal in that instance, in an unfair dismissal case, has to consider how well an employer adhered to the provisions of that code. So, like I say, important points. For those of you who have a pen, the codes are the Statutory Code of Practice, Handling Requests in a Reasonable Manner, ACAS Code, and the Right to Request Flexible Working, an ACAS Guide. They'll be on the ACAS website, no issues at all in finding those, hopefully, if you do a quick Google. But if anybody wants me to send you the links, then just drop me an email after this session and I'm more than happy to do so. In terms of the statutory right, the current right allows employees with at least 26 weeks continuous employment to make one request for flexible working in any 12-month period for any reason. The flexible working process, like I say, is triggered by the employee, who does that by making a written request to their employer. Upon receipt of a written request, the employer then has a 3-month decision period, and that decision period can be extended by agreement with the employee if necessary, within which to consider the request, discuss it with the employee, and to notify the employee of the outcome. Now, just on that, even though you have a 3-month window to deal with a flexible working request, I would strongly advise you to consider it before the expiration of that 3-month window. 3 months is a long time, and the sooner that you can deal with a flexible working request in practice, the better. Any flexible working request that is received by an employer has to be considered and dealt with in a reasonable manner. There's that word again, reasonable. But the employer can refuse a request if it is able to reference one or more of 8 statutory grounds for refusal, which are set out in the applicable legislation, which I referred to a couple of minutes ago. If an employer doesn't act reasonably, either in terms of the process or in refusing the flexible working request, then an employee can claim to an employment tribunal. Now, the biggest risk usually with flexible working is one of discrimination. And the reason for that is because usually flexible working requests are made by people with childcare responsibilities. Now, I don't think that is going to change anytime soon. But obviously, with the situation that we're in, I think we can certainly expect a wider group of employees to be wanting to make flexible working requests, which obviously widens the sort of risk profile, if you like. In terms of the changes that can be applied for them, like I say, an employee can essentially ask for whatever they want. But if we're being specific and if we're following the legislation, an eligible employee may request a change to their employment terms if the change relates to one of 3 things: a change to the hours that they work, a change to the times when they are required to work, and a change to the place of work. And again, for those of you who like to geek out on employment legislation, that's in section 80F(1) of the Employment Rights Act. Now, just before we sort of discuss those sort of 3 grounds, I think it's prudent to point out here that whilst the right to request flexible working is generally viewed as a right to request a permanent change, a permanent variation to terms and conditions, there isn't any prohibition on an employee asking for a temporary change. So do bear that in mind. Similarly, if an employee makes a request and through discussion you want to pose that the change actually is only in place for a temporary period, then that'll be okay. going back to the reasons then that an employee can make a request, those sort of categories really are very simple, but they do cover a massively wide range of possible working patterns, I think. And, if we look at it, the scope of the legislation effectively includes things like applications for part-time working, full-time working, annualized hours, compressed hours, flexi time, home working, job sharing, self-rostering, shift working, staggered hours, term time working, the list goes on. I think the point to take away from this is that there are actually very few limits as to what an employee can request by variation. So again, just something to be aware of. If an employee wants to make a request, then they have to follow a prescribed form, which again is set out in the legislation. And amongst other things, the request has to be in writing. It has to specify the change that they're seeking and when they want it to take place. And interestingly, it also has to explain the effect that the employee thinks that their request might have on your business, and also how they think that any issues could be dealt with. So it kind of forces the employee into your shoes a little bit, really, and gives them a responsibility, a legal responsibility to think about their requests, not only in personal terms, but also in commercial terms as well. And I do think it's a worthwhile exercise, actually, because in practice, when you start discussing the flexible working requests with your employees, if you have business concerns about the proposals that they're making, it's easier generally for you to discuss those, and in some cases the employee kind of gets it a little bit more readily than perhaps they would otherwise, because, like I say, they've already been forced to think about it. When you get a request under the statutory scheme, like I say, you have to deal with it in a reasonable manner, which I think, practically speaking, basically means talk to the employee about it and discuss it with them, and where you reach, on the face of it, slight impasses, try and overcome them. You need to notify the employee of your decision, whether it's yes or no, within the 3-month decision period. And you must only refuse a request, like I say, on one of the statutory grounds. Now, there are 8 statutory grounds, and I won't sort of read them all out. And again, but if somebody wants to sort of discuss these with me in more detail, then obviously you're free to do so. But generally, they relate to very broad business needs. So if, for example, you would incur additional costs through implementing the flexible working requirement, or you would suffer an inability to reorganise work amongst existing staff, or if you think that there will be a detrimental impact on quality or performance, then you can legitimately refuse a flexible working request. For the most part, I actually think that flexible working legislation is one of those pieces of legislation which is kind of in the employer's favour. We don't appear to get a huge amount of that at times, or it certainly doesn't feel like that. But flexible working is certainly one that I think is I say in your favour. Obviously, you don't have carte blanche to refuse any request, and I think that you still have to give some thought to why you need to refuse a request. But that sort of rigidity, I suppose, aside, the grounds are nice and broad, and you can, in some respects, refuse a flexible working request for any legitimate business reason. In terms of reaching an agreement, assuming that you can reach an agreement and you're not seeking to rely on one of the grounds for refusal, the flexible working request will constitute, like I say, a formal variation to the employee's terms and conditions of employment, and you therefore must confirm the details of the new arrangement in a formal way. You will be obliged to issue a Section 4 statement, which is basically a written statement of the changes to the contract, and you'll also have to provide, now following the changes in April, an updated Section 1 statement as well. You don't have to issue a brand new contract, but you can if you want to. Whether you issue a contract or not, though, like I say, having a written agreement in place to sort of outline the change is necessary. I don't really have a preference as to how employers seek to document the change, whether it's in a full-blown new contract or more of a side letter. Side letter generally seems to provide for an easier life, but it's entirely up to you to determine. Flexible working appeals. The legislation, interestingly, doesn't expressly require an employer to allow an employee to appeal against a flexible working request. I don't know why, because it doesn't make any sense. But that's, that is a position. However, ACAS strongly suggests that employees are allowed to appeal, and that is included in the codes which I referenced previously. And certainly from my perspective, you would want to allow an employee to lodge an appeal against any flexible working request that you refused, if only to cover off the discrimination risks and also any sort of trust and confidence type arguments that the employee might seek to raise. A bit like there being no right of appeal, there's no obligation on you to have a flexible working policy in place. But again, I think it's probably a good idea. I think many of you will probably have one as standard that we've sort of supported you with. But if you don't, and if you would like one, then obviously feel free to get in touch again, and it's something that we can certainly discuss with you. Pros and cons of flexible working then. There's both, I think. Each case will be inevitably different. But from my experience, I think that flexible working is definitely advantageous in terms of things like promoting a happier, loyal, more productive workforce. There is clear evidence from CIPD, I think, to show that employers who engage flexible working practices have reduced sick days. There is inevitably going to be a benefit to you in terms of attracting more talent or a higher perhaps standard of applicants, particularly, like I say, is the general sort of workforce expectation on flexible working increases. And don't forget, Brexit, it's still looming, and if you are going to be wanting to attract people from overseas, then you're going to have to work probably doubly hard, because they're going to have extra things to think about if they're going to be sort of relocating to the UK next year. From a cost perspective, flexible working can help you to save costs, because sometimes it can avoid redundancies. With home working type requests, it can help you to reduce costs in terms of office space and ancillary sort of administrative expenses in that regard. And obviously, if you have fewer people going into an office, you need fewer desks, and hot desking is usually far more economical. Cons. Trust. Do you trust people to work more flexibly? Big one to overcome for some employers. The sort of age-old discrimination risk that we've sort of covered a couple of times. Employers could clearly lay themselves open to discrimination claims if they only agree flexible working requests for certain groups of employees and exclude others from that. There could be a resentment among staff if they've had their requests denied whilst others haven't. And I think as well, people talk about mental health a lot these days, but a lack of contact with colleagues for people who sort of asked to work from home or perhaps asked to reduce their hours could affect their sort of mental health, and obviously in practical terms also limit the sort of cohesiveness of teams and the exchange of ideas. So pros and cons, but overall, I think that if you work well with your employees in respect to flexible working requests and try and achieve a sort of arrangement that works well for both parties, then it's probably more of a good thing than a bad. Right, 4 minutes over. Sorry. I hope you're all still with me. Not too much more to sort of cover now. But working from home. A bit like flexible working requests, I don't think it's going away. And as it stands today, home working is not something that employees have an automatic legal right to do. The government is tabling a proposal to change that. And obviously, if and when details of an automatic home working right are announced, we'll let you know straight away. But even though it's not an automatic right, I think it's something that will become a big part of the new normal. Again, when it comes to home working, each case will sort of turn on its own facts. And obviously there'll be some people within your workforce who it's absolutely not possible to allow to work from home, but there'll be others who actually it's perfectly doable. But I think wherever you sit on home working, whatever your sort of views are about implementing home working in the future, there are a couple of things that you can sort of start thinking about now, and I think some sort of headline points which might sort of get a few cogs turning are as follows, really. Home working policies. If you don't have a home working policy, you might want one. They will certainly be the best place to start if and when you do roll out more permanent home working. Again, for those of you who don't have one but who would like one, feel free to get in touch with us. Policies, contracts of employment. If your employee is going to work from home under the new norm, if you like, then their contract will need amending. Their normal place of work will become their home address, and obviously any paperwork that you have in place will need to reflect this. If you do allow people to start working from home, I think it would absolutely be to your benefit to build some flexibility into your contracts in this respect, especially if you're going to need a home worker to travel to and from the office or to and from clients. I think when looking at your contract, if you are going to change it, try and agree with your employee from the outset the terms and occasions when they'll be needing to come into work, with obviously a favour in your sort of part, favouring your part, that doesn't make sense, obviously maintaining favourability to yourselves and the business's needs. As well as making clear where an employee needs to work from. With home working, an employee's contract also needs to be very clear on when they will work. This is extremely important, because home working, whether you have sort of expressly mandated for this or not, does perhaps give some employees some slack during the working day. But you need to be clear on whether this is something that you will tolerate or not. If you want to enforce a 9-5 home working pattern, fine, tell your employees. If actually you're a bit more flexible and you don't really mind when employees do the work as long as they get it done, fine, make that clear as well. Either way, bear in mind the working time regulations. Too much fluidity in working patterns can blur the work-home boundaries, and there's obviously a risk of an employee not working enough but also working too much, and you don't want to get caught out when it comes to the 48-hour working time limits. So if you don't have an opt-out agreement in place already with your employees, it might be worth thinking about that. If you're looking at implementing home working, remind your employees to take their breaks if they're going to be working from home, in order to make sure that the working time regulation point doesn't become an issue, but also to make sure your employees don't burn out. I think that home workers can, very much end up with a sort of an always on mentality. Obviously leaving the office and driving home is very different to shutting your laptop and coming out of your kitchen, for example. And as an employer, you have to be aware of the impact that home working in that respect can have on your staff. Employees who have caring responsibilities, be very clear with them what your expectations are in respect of that, and put proper measures in place, so that if you do need to deal with an issue that arises, that you have a process to follow. So for example, parents, if they have childcare arrangements that need to be implemented before they start working, tell them that and keep on top of it as well, because if a person's childcare arrangements fall through, then this will affect the ability to home work. The onus is on the employee to make sure the arrangement's in place and not you. A couple of final points. Bills, costs. Are you going to be prepared to contribute to an employee's bills at home? It's totally up for negotiation. It's not an obligation, but it's something that you need to be clear on. Tax, very complicated. I'm not clever enough to talk to you about tax, but it's something to sort of think about. Home workers can claim a rebate, as I understand it, for home working. And also, quite terrifyingly, I only found this out the other day when I was sort of prepping for this, home working can actually affect an employee's mortgage. because it shifts into a person operating from home or something like that. So make sure that you flag this up with your employees, because you don't inadvertently want to be contributing towards detriment in that respect. Final point, I think, is with home working, make very clear to your employees that all your normal policies and procedures apply. Disciplinary still applies, your ill health reporting procedures still apply. They still have to request annual leave. They can't just have a day off because they're working from home and you're being more flexible. Your social media IT policies also apply. And if you want to carry on monitoring emails and telephone calls with an employee who's working from home, just tell them. And bear in mind as well that you won't be able to do that if the employee is using their own computer to work. That's a breach of the Computer Misuse Act 1990. If you want to monitor your employees' laptop computer activities, you have to supply the equipment. Right, so I think that's probably all the sort of key points that I had on my list in respect of home working. And like I say, I hope that's given you a little bit of food for thought, perhaps, in terms of what you might need to consider if you are looking at implementing a more kind of permanent home working arrangement in the future. More than happy, though, to sort of chat through anything that any of you have in respect of home working or any of the points that we've talked about earlier. And yeah, I hope that you enjoyed that. I know there's a couple of outstanding questions and I'll come back to you on those separately. But for now, enjoy your weeks, get that laptop out in the garden and enjoy the sunshine. I'll hand you over to my colleague Louise just to say a formal goodbye, but take care.
Thank you very much, Charlotte, and thank you to everyone for attending today, as always. So I just wanted to highlight, as Charlotte said, we will come back to you on any questions that haven't been answered. Not surprisingly, there was a few more furlough-related ones coming through as well, so we'll come back to you on them as soon as we can. So I know we've got a large number of clients and also non-clients on the webinar today, and some of you have been, on a few before, so you do know about the services that we provide. I have been having a lot of sort of 15-30-minute conversations with people about areas that we don't currently support them in, and how we can support them in moving forward. So I think what COVID has done is made people realise what they don't have in place. And they're trying to get those things in place moving forward to prevent any other issues arising. So if there's anything you need, employment law, HR, health and safety related, just get in touch and we can have a 15-30-minute chat to discuss where you're at. And then keep an eye out on your emails and our social media channels. So we've got a couple of webinars coming up, which we'll send dates out for shortly. So we'll have a live Q&A on redundancies with wonderful Charlotte and also our Managing Director, Gavin Howarth. We will be hosting one with Wendy, who's one of our advisors, which will be about termination under 2 years. And Charlotte, again, who's been doing a lot of the content, we'll be doing like a video mini-series on redundancies. So not a nice subject, but businesses are having to make those decisions. So keep an eye out on our emails and our social media channels, and just give me an email at louise@howarth-uk.com or a call if you want to discuss anything further. Thank you for your time and take care.